Welcome to my YouTube channel, Legal Information Law Insights. I am Advocate Mukund Mahajan. In today's video, we will discuss one of the most crucial procedures under Indian succession law, probate of a will. We'll cover what is probate, when is it compulsory, step-by-step court procedure. Let's begin. What is probate? Probate is a judicial certification process under the Indian Succession Act, 1925, through which a competent court verifies the validity of a will. The court confirms the will was duly executed by the testator was of sound mind and acted voluntarily, all legal formalities were complied with. Once granted, the probate certificate legally empowers the executor to administer and distribute the estate according to the will. When is probate required? Probate is compulsory when the will is made by a Hindu, Buddhist, Sikh, or Jain, and the property is located in the presidency towns of Mumbai, Chennai, or Kolkata. In other regions, probate is optional but highly recommended to prevent inheritance disputes, fulfill requirements of banks, housing societies, and revenue offices, facilitate smooth transfer of title. Case law Clarence Pais vs. Union of India, 2001. The Honorable Supreme Court clarified that probate is not mandatory outside presidency towns, unless required under state laws. Step-by-step probate process. Step 1. Filing the probate petition. Under Section 276, Indian Succession Act, 1925, the executor files the petition in the district or high court having jurisdiction. The petition must include full name, address, and death details of the testator, estimated value and description of assets, executor's credentials, a copy of the will. List of all legal heirs. Step 2. Submission of documents executor must submit. Original will, death certificate of the testator. ID and address proof of the executor. Valuation certificate from a chartered accountant or revenue officer, list of legal heirs, affidavit supporting the petition's contents. Step 3. Court notices and objections. As per Section 283, the court will issue notices to legal heirs, publish a public notice in a local newspaper inviting objections or caveats. Time limit. Objections must generally be filed within 45 to 60 days. Step 4. Hearing and objection disposal. If a legal heir files a caveat, the case converts into a testamentary suit. Both parties can present evidence orally or via affidavits. If uncontested, the case proceeds ex parte based on documents. Step 5. Proving the will under Bharatiya Sakshya Adhiniyam, 2023. As per Section 63, Indian Succession Act, will must be executed by the testator, attested by at least 2 witnesses. Under Section 59, Bharatiya Sakshya Adhiniyam, 2023. At least one attesting witness must testify in court. Will must be signed in the presence of both witnesses. Affidavit evidence is permitted at the court's discretion in uncontested matters. Note: a registered will still requires proof of due execution. Registration alone is not conclusive proof of validity. Step 6. Grant of probate. Upon satisfaction, the court issues a probate certificate under Section 222, empowering the executor to pay off the testator's debts, distribute and transfer property as per the will, fulfill all duties and obligations stated in the will. Court fees and timelines. Court fees vary across states and are linked to the value of the estate. States like Maharashtra, Karnataka, and West Bengal have revised slabs: small estates, below 10 lakh rupees, fixed fee; large estates, above 50 lakh rupees, slab-based percentage. Timelines for clearance of case by court. Uncontested cases 6 to 12 months, contested cases 1 to 3 years or more. Practical advice for executors. Keep the original will and related legal documents safe, obtain property valuations early, communicate with legal heirs before initiating proceedings, hire an experienced probate lawyer, actively follow up on court dates and notices, maintain full transparency. Concealment of facts can delay or derail the process. Conclusion. Probating a will ensures legal sanctity and facilitates a smooth and dispute-free transfer of assets. With digital reforms and the introduction of the Bharatiya Sakshya Adhiniyam, 2023, the process is becoming more transparent, accessible, and efficient. Thanks for watching this video. If you found it informative, please like, subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind. Jai Bharat.